Good morning, everyone. Let's get started. I want to welcome everyone to this briefing on rental housing and algorithmic collusion. I'm Congressman Jerry Nadler, ranking member of the Judiciary Committee Subcommittee on the Administrative State, Regulatory Reform, and Antitrust. And I want to thank our distinguished witnesses and members for participating. Before we begin, I want to introduce Hillary Green, Senior Counsel for the Antitrust Subcommittee. She has done a lot of work to help put together our panel and this morning's discussion, and I want to thank her for her work. In addition, since we are all spread out and navigating this technology together, she may come onto the screen from time to time to make adjustments and make sure we are on track. Also, we will be recording this event, but for those who are watching this briefing live, I would ask that you please keep your cameras off and your microphones muted so that we can focus on the speakers. With that, I will now recognize myself for a brief opening statement. What we are witnessing in the rental housing market is nothing less than a modern form of price fixing. It is an affront to the fundamental principles of competition and fairness that are supposed to govern our economy. In decades past, price fixing occurred in smoke-filled back rooms. Today, it can happen with just a few lines of code and an algorithm. That doesn't make it any less dangerous. In fact, it may be more insidious because it operates behind a veil of technological complexity that shields its architects from scrutiny. Today's briefing is an effort to pierce that technological veil and shine a spotlight on the harm to society caused by this practice. So how does this work? Rather than competing to provide tenants with the most attractive rents, landlords are sharing with one another non-public and competitively sensitive information about occupancy levels, rental rates, and lease terms through algorithms that use this information to propose so-called rent recommendations. In fact, if landlords try to deviate too much from the recommendations set by the algorithm, they risk losing access to the algorithm altogether and thus facing a distinct disadvantage in the rental market. It is in this way that such collusion artificially restricts the supply of housing and disincentivizes landlords from trying to win over tenants by setting their rates at competitive levels. While not the only factor, this collusion contributes to the affordability crisis crushing many Americans. The Council of Economic Advisors has estimated that just in 2023, tenants overpaid rent by $3.8 billion as a result of algorithmic collusion. That's a staggering number on its face. Just consider what that means for individual families. The council also found that the renters in algorithm utilizing units overpaid by an average of $70 a month, or 4% of rent, on average nationally. Moreover, in 6 major metropolitan areas, the cost exceeded $100 a month. Keep in mind that the council's estimates are conservative and likely lowball these numbers. This is money that no one should overpay and that many, often the most financially vulnerable, cannot afford to pay. A Harvard study shows that half of all renters are considered cost-burdened, meaning that they spend more than 30% of their total income on housing and utilities. 20% are severely cost-burdened, which means that figures more than 50% of their total income. It is clear that so much of our quality of life is dictated by where we live and how much we pay for housing. While our primary focus today is on algorithmic collusion in rental housing, it also has consequences for the more general issues of the increasing role of private equity in the context of housing and the impact of algorithmic pricing in other industries. This is a matter for federal enforcement. It is also a matter for state action, and it is decidedly also a matter for legislative oversight and reform. If society does nothing, we send a dangerous message that colluding through code is a loophole in our antitrust laws. I reject that, and I am pleased that we have the opportunity today to hear from experts helping to ensure antitrust remains on the cutting edge to help us protect consumers. It is now my pleasure to recognize the gentlewoman from Washington, Ms. Jayapal, the co-chair of the Monopoly Busters Caucus, which is co-hosting this event, for an opening statement.
Thank you so much, Ranking Member Nadler, for your leadership on this issue and to the Antitrust Subcommittee. On behalf of the Monopoly Busters Caucus, I'd like to thank all of our participants, our witnesses for attending this critical briefing. I formed this caucus with my co-chairs, Representatives Pat Ryan, Angie Craig, and Chris DeLuzio, to really take on and focus on the issue of corporate consolidation and corporate concentration of power, which I believe is one of the root causes of rising prices that Americans are experiencing in all aspects of their lives, as well as of wealth and income inequality more broadly. We are organizing members of Congress around an antitrust and economic agenda that centers working people, consumers, and small businesses, and the challenges they face on affordability around kitchen table issues like groceries and healthcare. And nothing could be more of an affordability and kitchen table issue than the place where the kitchen table is located, our homes, the place where we sleep, eat, work, play, raise our kids. Without a roof over our heads, so much else collapses. And the instability that people feel as they helplessly watch their rent skyrocketing, the biggest expense out of their paychecks, or as they completely write off the idea that a working family would ever be able to own their own home. Across the country, we are facing a deepening housing crisis as rent increases significantly outpace wage growth. In many cities, working families are being pushed out of neighborhoods that they've lived in for generations. And while inflation and lack of housing supply are certainly relevant, one of the key factors that has been recently identified is pricing algorithms. Large corporate landlords, particularly in multifamily housing, are increasingly using software to set rents. These algorithms analyze market trends, vacancy rates, and even competitor pricing. And when multiple landlords in a city use the same algorithm, and that algorithm is designed to maximize profits by keeping prices in sync, the result isn't a fair market. It's coordinated price setting, which plainly violates our antitrust laws and harms consumers. I represent the city of Seattle, and my home district of Seattle is a perfect example of this firestorm. The city has some of the highest rents in the country, 47% higher than the national average, and on par with cities like Los Angeles. In 2022, our state attorney general sued RealPage and 9 local landlords under the state consumer protection laws, estimating that 800,000 leases in Washington state were priced using RealPage software between 2017 and 2024. The city of Seattle has followed this up just last month by banning the use of this software that uses algorithmic pricing, a law that went into effect at the beginning of this month. At the federal level, the Biden administration antitrust enforcers at DOJ took on this illegal conduct along with numerous state attorneys general and private renters to bring the lawsuits against these greedy corporate landlords and rent-setting software companies. And today, we are just thrilled to have with us some of the people who led these lawsuits to help us understand the problem. As members of Congress, we can hold the Trump administration accountable to continuing enforcement actions. We can also advance legislative solutions like the bill offered by my colleagues Chuy Garcia and Becca Balint that prohibits landlords from using harmful price algorithms. The Monopoly Busters Caucus is committed to supporting all efforts to crack down on unscrupulous actors, driving up housing prices, and to shine a light on the anti-competitive practices in rental housing. At the end of the day, the fight for fair markets isn't just about economics. It's about dignity. When rent becomes unaffordable due to collusion, algorithmic or otherwise, we're not just talking about numbers on a spreadsheet. We're talking about families choosing between groceries and rent, seniors being priced out of their homes, young people giving up on dreams of independence. So let's bring antitrust into the algorithm age. Let's work together to protect housing not only as a commodity, but as a human right. And let's make sure the tools we build serve the public good, not private exploitation. And with that, I yield back.
Please continue, sir. Mr. Nadler.
Yeah, thank you. I now recognize the gentleman from Georgia, Mr. Johnson, a distinguished member of the Antitrust Subcommittee, for his opening statement.
Thank you, Representative Nadler, and thank you to the panelists who are here today to share with us, and thanks to all the staff who put this together. My constituents in Atlanta, in the Atlanta metropolitan area, are worried about how they will afford to keep a roof over their heads. It's a problem all over the country, but in my hometown of Atlanta, rent just keeps going up, and buying a home is increasingly out of reach now that people need a six-figure income to afford a mortgage. Private equity firms are grabbing up housing stock and becoming the country's biggest landlord. Inflation is growing, and now with Trump's tariffs making building materials more expensive, rental prices are expected to keep rising. Adding to the problem are these anti-competitive algorithms, which allow companies to collude and jack up prices. And let's make no mistake about it, when private equity firms own much of the housing, both apartment rentals as well as single-family home rentals, then you see an explosion in the use of these anti-competitive algorithms to jack up prices. In Georgia, according to a study that was highlighted by Senator John Ossoff in his investigation of these high rental prices in Atlanta, a Georgia state study found that private equity owns 30% of Metro Atlanta's single-family rental homes. And these institutional investors purchased $1 billion worth of Atlanta homes in 2024 so that they can rent them out. And so they drive up the prices, the selling prices of the homes. And then when they secure the homes and put renters in them, they jack up the rental prices. And so it's only three corporations that own much of that private equity stake in Atlanta home building or Atlanta home selling. And those three corporations are Invitation Homes, Premium Partners, and Amherst Holdings. Even though I knew algorithmic pricing was a problem in general, I was appalled when I saw how it affected my own district in the report that the White House Council of Economic Advisors put out last December. That report looked at the use of RealPage, a software that allows a city's landlords to share their private rental information and use algorithms to maximize the rents they all charge. It's collusion that is happening in the cloud instead of in the smoke-filled room. The CEA report showed that out of all of the metro areas in the United States, Atlanta was the one with the highest markup attributable to RealPage. Atlanta renters paid an average of $181 more for their units every month because their landlords were coordinating using RealPage. Without true competition, keeping prices in check, Atlanta landlords extracted over $2,000 extra each year from their renters, and that's just wrong. I was proud to co-sponsor the Preventing Algorithmic Facilitation of Rental Housing Cartels Act, introduced last Congress by Representative Balint and Representative Garcia. And I'm looking forward to supporting it again this Congress. And I'm grateful for the public servants like Attorney General Platkin and Ms. Mekki, who have litigated to hold RealPage accountable, and for others in this antitrust fight, such as Mr. Baer and Mr. Hepner. I'm looking forward to hearing our panelists' remarks and to having a fruitful discussion about how we can end anti-competitive practices that are hurting everyday Americans, because we all know the rent is just too damn high. Thank you, and I yield back.
Thank you. At this time, I am pleased to introduce Attorney General Matthew Platkin, who has led the New Jersey Department of Law and Public Safety since 2022. He has sued RealPage and 10 of the largest landlords operating in New Jersey for violations of the federal Sherman Act antitrust laws, as well as state antitrust and consumer fraud laws. We are grateful that he has taken time out this morning to be with us and to share his perspective on this important issue. Attorney General Platkin, I now recognize you for any remarks you may have.
Thank you, Ranking Member Nadler and all members of the committee, as well as Chair Jayapal. I want to thank you for the opportunity to be here today. Before I say anything, I should note that I'm here as a representative of a number of states that have brought suits against RealPage, and many of my Democratic Attorney General colleagues. I want to who are not here. I want to recognize them, in particular, DC Attorney General Brian Schwab, who has done extraordinary work on this case and many others, but certainly with respect to RealPage. You've all in your opening statements really summed up the theory of our case against RealPage. Obviously, like most of your, if not all of your states, New Jersey is also facing an affordability crisis, and for many, housing costs are the highest, the greatest expense that we face each month. New Jersey has some of the highest rents in the nation. So what our RealPage case really is, and frankly, all of our antitrust work that we do at the state level is focused on, is protecting the consumers, ensuring that fair marketplaces exist, and that people aren't paying more because businesses are able to extract profits based on their market size and share. And so the RealPage suit, which we brought in New Jersey in April of 2025, and as has been noted, there are several other suits, both brought by the federal government as well as states across the country. It targets both RealPage, the software producer, and 10 of our largest landlords in the state, which collectively control tens of thousands of apartments and rental units throughout the state of New Jersey in cities like Jersey City, Camden, Trenton, and others. The suits filed both under the Sherman Act, Section 1, as well as the New Jersey Antitrust Statute and our Consumer Fraud Act, seeks a range of injunctive and declaratory relief, as well as a range of penalties. The theory, as has been noted, is essentially that RealPage acts as a modern-day price-setting cartel for rents. They have proprietary software built by the same people who built the price-fixing software that airlines used in the 80s, that allows them to take very sensitive proprietary information from some of the largest landlords in the state and use that to set rents that landlords adhere to. They then use a variety of techniques to ensure that landlords are following these rents, and the landlords in turn are marketing their properties as being essentially market rate when in fact they're not. The more landlords, as has been noted, that participate in this scheme, the floor that RealPage can set goes up. It's like any other cartel. When more parties participate, the rent or the price that they can charge increases. So that's essentially what's happening here. And RealPage is using, as I said, a variety of techniques to enforce its rents. They use hard floors on their proprietary software. They even use what they call secret shops, where they go out into the field. They send people out into the field to see how low a landlord would drop a rent, and then obviously address it if a landlord goes below the hard floor. So landlords are incentivized to follow the rents that RealPage sets. And as our complaint shows, landlords essentially virtually always follow the rents that RealPage sets if they're participating in it, and they make more money as a result. As one landlord put it, and we have this in the complaint, one landlord executive said this is the classic price fixing, his own terms. So what we're seeing as a result of this is that people in New Jersey and across the country that are using RealPage are paying artificially inflated rents, being told that's what the market would bear, when in fact the market would bear a lower price, but for RealPage and these landlords' collusive conduct, which violates both state and federal antitrust and consumer statutes. And that is the crux of our complaint. In New Jersey, like I said, we're litigating this in the District of New Jersey. There are a number of other cases being litigated across the country. There's the DOJ case in North Carolina with several of my colleagues, North Carolina, California, Colorado, Connecticut, Minnesota, and Oregon, as well as Washington. That case has a motion to dismiss that's pending. There's private litigation. There's the DC litigation that I mentioned. DC has already settled with one of the landlords. And then there's cases in Maryland, Arizona, and Washington that are in various stages of litigation. But again, the point here is that, as with all of our antitrust work, and I know this is the focus of this committee, I believe, and I think I speak for the AG community, we believe that states can enforce our antitrust laws alongside the federal government and ensure that businesses are not able to use their market share and power to force consumers to pay more than they should. That's the core of our theory against RealPage. It's the core of our theory against virtually all of our antitrust cases. I'm very honored to be here, and I'm happy to talk more about the specifics of our complaint as well as our antitrust enforcement work more broadly.
Thank you. I realize I inadvertently skipped Mr. Garcia for his opening statement. So, Mr. Garcia, you're recognized for your opening statement.
Thank you. Thank you, Ranking Member Nadler and Congresswoman Jayapal for convening this briefing. And of course, thank you to all the panelists. Oh, I think I'm on now. For joining us today. As my colleagues have pointed out, the country is facing a crisis of affordability. The cost of living is just too damn high, and families in my district and around the country are struggling to make ends meet despite working very hard. This crisis extends to the housing market and specifically to rental housing. We're seeing significant increases in rent that are continuing to burden working families. In Chicago, where half the population is renting, the median cost of rent and utilities increased by 28% between 2000 and 2023, 3 times more than the increase in median household income over the same period. Approximately half of renter households in Chicago are cost burdened, meaning that they spend more than 30% of their income on housing. I represent a working class and majority Latino community in the Chicago area, so I hear from many constituents who are renters and that have been suffering from rents that are rising faster than in most other cities nationwide. There are several factors, of course, that contribute to the explosive growth in rents, including the supply of rental housing, gentrification, and the lack of rent control ordinances in many jurisdictions. But one factor we cannot ignore is corporate greed. Many landlords are owned by large corporations and private equity firms, which are relentlessly stripping our communities of their hard-earned income for profit. And as technology continues to advance, predatory companies take advantage of it to fuel their anti-competitive conduct. Algorithmic price fixing in rental housing is a perfect example of this. And that's why this briefing is so important. Chicago has not been immune to this collusion by RealPage and corporate landlords. Tens of thousands of units are priced with RealPage's price setting algorithm, including an estimated 34% of multifamily rental units. And in 2021, RealPage was acquired by the Chicago-based private equity firm Thoma Bravo for approximately $10.2 billion. This is a perfect illustration of the problem. a private equity-owned company, sells its algorithmic price-fixing software to corporate landlords who jack up rents on families in Chicago that are already struggling to stay afloat. It is anti-competitive and it is unlawful and it must end. That's why I've been leading on this issue for years. In 2022, I led a letter with my colleagues calling for DOJ and FTC to investigate RealPage for its anti-competitive practices. I was pleased to see DOJ conduct this investigation and file a lawsuit in 2024 with several states against RealPage and, of course, violations of the Sherman Act. And that's why I introduced legislation with Congresswoman Ballard and Senators Wyden and Welch that would crack down on this anti-competitive practice and make this kind of digital price fixing a per se violation of the Sherman Act. We will soon be reintroducing this important legislation. Congress must act, but this conduct is already unlawful under the Sherman Act, and that's why I fully support the lawsuits brought about DOJ and the states, including the lawsuit that Attorney General Platkin just described. We need a whole of government approach from lawmakers and antitrust enforcers to protect our communities from this predatory conduct that's driving up the cost of rental housing nationwide. Thank you again, Ranking Member Nadler and Representative Jayapal, and to the witnesses for being here today. I look forward to our conversation.
Thank you, Mr. Garcia. And we'll now return to Attorney General Platkin, and thank you for your participation, Mr. Attorney General. I understand you have a time for a few questions, so I'll begin by recognizing myself. Your office has a very active antitrust docket. I understand that New Jersey is a lead state plaintiff in the Apple Section 2 antitrust case involving smartphones. It is also participating in a number of other tech antitrust cases. Is there any connection between that work and the RealPage case?
Well, thank you, Chairman, for that, Ranking Member, excuse me, for that in that question. You know, I do think there's a connection, and I mentioned this in my opening remarks. Antitrust fundamentally, you know, these cases are technical and complex, but they boil down to big businesses using their power to profit and force consumers to pay more than they should. So the Apple suit is a great example of that. If you just looked at what the iPhone should cost, if you adjust the 2007 iPhone price when the iPhone was introduced for inflation, it should be about 4 times cheaper than what people pay now for an iPhone, which is, of course, something, whether it's an iPhone or other form of smartphone, I think it's fair to say virtually every adult American has, and probably more kids than we'd like. So we're seeing a huge impact on consumers' pocketbooks at a time when affordability is, I think, the number one issue facing most Americans, certainly most New Jerseyans. Same with RealPage. Big business colluding to use its market share to force consumers to pay more for a product or a service, or in this case, housing, than they need. That's why I think we have heavily invested in antitrust. I created an antitrust section in our department, and it has been one of the most active sections we have, holding a lot of times big tech accountable, because I think, as was said in several opening remarks, the new form of cartel and price fixing activity really is done through algorithmic and other form of technological collusion, not necessarily through the old smoke-filled back rooms. They try to legitimize it through fancy technological platforms, but the same principles apply. The same type of price fixing conduct applies. And at the end of the day, the same people get screwed. It's the regular consumers who don't have the ability to get around that type of price fixing conduct, don't profit off it, and pay more as a result.
Given your office's interest in housing affordability, why is antitrust an important tool to combat the issue of algorithmic collusion?
Well, I think we use every tool at our disposal. So, like I said, we've filed claims under our state and federal antitrust authorities, as well as consumer protection laws. I mean, I take a sort of simple view of this. I don't view antitrust as separate from consumer protection work. I think antitrust, at its core, when the Sherman Act was passed and all the work that this committee and others have done, is to provide tools to ensure that the largest businesses can't unlawfully profit off based on market share, and can't exclude other businesses and prevent a fair playing field. It's a way of protecting the little guy, both the consumer as well as our small businesses and growing businesses. So I really view antitrust as a core consumer protection tool. I think there's been growing interest at the state level, both in enforcing federal statutes as well as enforcing our own state antitrust statutes. I think this is going to be, given the size and concentration of some of the largest companies and the ability for them to extract massive profits at the expense of ordinary Americans. These are going to be some of the biggest fights we're going to see, both in the courtroom and in the court of public opinion, I believe, over the coming years.
Thank you, Mr. Attorney General. I now recognize Ms. Jayapal for her questions.
Thank you, Attorney General Platkin, for your great work and for being with us today. I completely agree with you that this is a core consumer protection issue. And for people who may not understand antitrust specifically as a word, they definitely understand consumer protection. I have a two-part question for you. First, RealPage claims that it doesn't dictate prices. It says it just recommends them to individual landlords who make the ultimate decision. And I wanted to have you respond to those claims and explain what exactly is happening here. And then second, in your case, you assert that RealPage's software artificially limits the supply of multifamily housing units. And I was hoping you could explain that, because it actually, in my opinion, it's leading to landlords keeping apartments vacant in some cases, which seems particularly criminal in this very tight housing market where we have so many issues with affordable housing. So if you could answer those two, I'd appreciate it.
Sure. And I think thank you so much for that question. And I'm from New Jersey, so I sort of laugh when I hear that these are recommended. It's like Tony Soprano didn't just recommend tributes paid by the businesses he was working with. But this is classic cartel behavior. And I'm given we have ongoing litigation, I'm going to stay to the facts and allegations presented in our complaints. But if you just look at our complaint, we lay out very clearly on both points how what RealPage is saying is bogus. So participating landlords themselves say that they adhere to RealPage's rental recommendations, the vast majority, in some instances, over 90% of the time. So these are not just suggestions that landlords are free to deviate from. By the admissions of the participating landlords, they are following quite religiously the recommendations, the rent, that RealPage is setting. And then, as I noted earlier in my remarks, RealPage is using a number of tactics to, in fact, ensure that landlords follow them. They're sending people out. They're testing it themselves. Can I get a rent better than what RealPage would say? And if they don't, there's consequences. And it's true both on the rent setting side and, as you noted, on the recommended occupancy levels. In fact, one landlord said that the idea of more heads in beds is always the best strategy is just not true, because they've realized that they can artificially reduce supply by following RealPage's algorithm in a way that, in some cases, in our complaint shows, produced millions of dollars more in income for these landlords. So they benefit. They make more money. RealPage makes more money because they have more participating landlords that are using their software. And the people who pay the price are people trying to rent apartments in Jersey City or Camden or Trenton or communities across New Jersey or across this country. And so that is really the crux of what RealPage is doing. And the more landlords, the bigger and more market share they gain, the more they're able to charge consumers. And that is classic monopolistic behavior. That's classic cartel behavior. Those are not recommendations. Those are, in fact, core monopolistic strategies.
Well, I really appreciate your attention on this, and thank you again for all of your work and for being here. And I yield back to the ranking member.
Thank you, Ms. Jayapal. Mr. Johnson, you are now recognized for your questions.
Thank you. And thank you, Attorney General Platkin, for your work and your leadership in this very important area. In 2021, this RealPage was acquired by the private equity firm Thoma Bravo, a San Francisco, Texas-based firm. And I think RealPage is a publicly traded company, or it could be Thoma Bravo. I just did some since when I heard Rep Garcia mentioned that, I just went to the internet, started looking at that. But have you been able to determine in the litigation any information about the ownership of RealPage and who owns the owner of RealPage? In other words, one private equity firm that may be owned by other private equity firms that are then colluding through their joint ownership of a particular software company to engage in vulture capitalism.
Yeah, we thank you for the question, Representative Johnson. In our complaint, we identify RealPage as being a public company from 2010 until December of 2020, when it was purchased, as you note, by the Chicago-based private equity company Thoma Bravo. I don't have further information on their ownership structure that may come out during the course of the litigation, but obviously the impact of private equity on the housing market more broadly is something that we have paid very close attention to.
Thank you. Talking about information that is already public, have you learned anything in litigating this case that has surprised you?
I think one thing that surprised me is just how brazen this scheme was. They weren't hiding the ball. As I noted, we have communications, this is in our complaint, from participating landlords to RealPage celebrating the scheme as, quote, classic price fixing, which if I was engaging in a price fixing scheme, I probably wouldn't put in an email. But they were so open about it. They were able to make huge amounts of money off the backs of working in middle class families in New Jersey who are struggling. And you ask anybody in our state, and I suspect in your state, and in probably most states, if not all, what's the biggest concern? It's how am I going to pay for the roof over my head for myself and my family? And here we have a company designed to pretend that the housing market, which is already expensive enough, is even more expensive than it is, just so they can make more money. And you have landlords jumping over themselves to participate in that. So I will say that frankly surprised me at how brazen it was. And that's why I'm proud to be litigating this case, bringing this case on behalf of the people in New Jersey. And I know I speak for all of our colleagues that we're going to fight tooth and nail to get the relief they deserve.
Well, thank you. And before I yield back, I just want to make the point that these same folks who are heavily invested in these private equity firms are the same folks who are benefiting under the big ugly bill that was passed. Their capital gains taxation rate is, of course, much lower than the rate that workers have to pay who actually go out here and do the work. And so with that, Mr. Chairman, I want to thank you for your work, General Platkin, and yield back to yield back. Thank you.
Well, thank you, Mr. Garcia. You are now recognized for your questions.
Thank you, Ranking Member. Attorney General Prackton, thank you for being here this morning, and of course, the work that you and your team are doing. Algorithmic collusion and price fixing in the rental housing market is not an issue affecting only people in Illinois. It's something that you've seen in New Jersey and addressed head on with the lawsuit that you filed earlier this year. This can be a complicated issue for people to understand, and so it's antitrust law more broadly. I think it's important for the staffers in attendance to understand how this affects their bosses' districts. So let me ask you, how does antitrust enforcement on this issue and others drive down costs in local communities?
It's the core question, Representative Garcia. And I have to say, your Attorney General, my good friend Kwame Raoul, is an exceptional advocate on these issues and a great leader. So I have to give him a shout out.
Yes.
Look, what we're seeing in our marketplace right now is very large companies, some of the largest we've seen since the creation of the Sherman Act, that have incredible market power and are using it to screw consumers. I think that's the core story of what they're doing right now. And that's true specifically, I think, in the large tech industry players. And so, take Apple suit, which I mentioned. You know, somebody may go to the store and is paying $1,700 now for an iPhone that you basically can't live without a smartphone anymore. And Apple, through, as we allege in our complaint, which just, by the way, survived a motion to dismiss, which is a significant development in that case. Apple, through its incredible market share and unlawful conduct, has been able to charge people a whole lot more for these products. RealPage, you're paying more in rent based on an algorithm set by a Texas-based company that you've probably never even heard of. When you go online and search something, we've had antitrust cases about the control that companies have in the search process and the ads you're paying for and how it affects your daily life. And it's true both in the antitrust context, it's true probably in all walks of life. It's certainly true with respect to discrimination you may experience. Algorithms that are operating behind the scenes are affecting your life on the ground. And technology is a very powerful tool. There's a lot of upside and positives about new technologies. We should celebrate that and encourage innovation. But when they violate our laws, it's no different. You can't say you're not violating the antitrust laws just because you do it through a very complicated algorithm created by a bunch of computer programmers and not in a smoke-filled back room. The smoke-filled back room may look different, but it's the same conduct.
Thank you very much. And of course, I look forward to working with you, with RAG, and with all of the folks involved in this to protect our communities. Thanks again. I yield back.
Thank you. And before we turn to our panel of witnesses, I want to thank Attorney General Platkin for speaking with us today and for his work to protect renters in New Jersey and across the country. I will now introduce our witnesses. Doha Mekki served as the Acting Assistant Attorney General for the Antitrust Division of the U.S. Department of Justice. Previously, she was the Principal Deputy Assistant Attorney General under Assistant Attorney General Jonathan Cantor. It was during her tenure at DOJ that the department brought its landmark suit against RealPage. She is currently a senior fellow at the University of California, Berkeley Center for Consumer Law and Economic Justice. Lee Hepner is senior legal counsel for the American Economic Liberties Project, working on anti-monopoly law and policy. His work addresses corporate power at the local, state, and federal level. William Baer served as the Principal Associate Attorney General at the Department of Justice. Prior to that, he served as the Assistant Attorney General for the Antitrust Division at DOJ. He is currently a visiting fellow in governance studies at the Brookings Institution. Mr. Mekki, you may begin.
Thank you so much, Ranking Member Nadler. And thank you to Representatives Jayapal, Johnson, and Garcia and the Judiciary Committee staff for being here today, doing the people's work and tending to the people's business. I also want to thank my friend General Platkin for being here on behalf of the AG community that has been so focused on these issues and were great partners to us, especially the AGs of North Carolina, my home state, California, Colorado, Connecticut, Illinois, Massachusetts, Minnesota, Oregon, and Tennessee, who signed on and really are litigating shoulder to shoulder with the United States Department of Justice in its lawsuit against RealPage and some of the largest landlords in America that are alleged to have colluded through algorithms to artificially align pricing and really subvert competition in these important markets. As the ranking member noted, I served for 10 years in the Justice Department's Antitrust Division, which I believe was the crown jewel of the DOJ. And during my time as acting assistant attorney general and as the principal deputy in the Antitrust Division, I helped file and quarterback generational monopolization and collusion cases against RealPage, Visa, Ticketmaster, Google, Apple, AgriStats, some of the airlines, chicken processors, supply chain companies, and food companies. And really, the theme there is really the theme that is really paints the backdrop against which this hearing occurs, which is that there's a painful cost of living crisis in this country. And after 40 years of consolidation, has reduced and kind of hobbled markets into monopolies and oligopolies. We see a proliferation of algorithms that boost big corporations' ability to raise prices and create artificial scarcity. And so we're left with a single kind of terrifying impression of how a lot of these markets operate, which is that any competitor that's willing to pay the price and share information really can become an all-seeing, all-knowing price setter. And Americans lose when markets are hampered in those ways. And I'm sad to say that we see these kinds of collusive schemes in healthcare and transportation and food and grocery markets, where algorithms are combining data to keep prices high and inventory artificially low. And it's particularly pronounced in housing markets. At a high level, the committee should understand that the deck is stacked against Americans looking for housing. And that's especially true for younger people. And it's true for everybody who is sort of in the kind of normal part of the income distribution. And I want to thank Representative Johnson in particular for highlighting the issue of institutional buyers that are coming in to buy up housing supply. There are non-US based entities that are buying up housing and farmland. And if you can get through that thicket, you can, expect to face off with real estate professionals that collude on broker commissions. There's allegations of anti-competitive practices and the MLSs that limit which homes you can buy. There's concentration among mortgage brokers and financial services companies that sort of help underwrite and finance the home buying process. And that's to say nothing of very serious concerns that have been leveled in appraisal, title insurance, and other ancillary services. And so there's already a huge segment of the market that isn't even available to renters. And so then you face the available housing supply in terms of the rental market. And of course, we know from the Justice Department's complaint and other states' complaints that some of the largest landlords in America were using RealPage's software to feed in real time data about occupancy, about pricing, about renewal terms, about concessions like free parking or a month free. And when they weren't using the algorithm to kind of align their pricing, they were also getting together in the physical world. And so it really paints a picture of a painful cartelization of our rental housing market. And so I want to spend just the little bit of time that I have left talking about some of the legal framework that we helped set up when we were at the DOJ. And it really starts with the story of chicken processors. There are more than 20 sort of substantial chicken processors in this country. And we learned that roughly 90% of the industry was using these sort of more analog tools to share information about wages and benefits and subvert the competitive process for how slaughterhouse workers' wages and benefits were set. And so seeing this really caused me to think harder about the institutional and legal doctrinal frameworks that we had set up and we had been following in the Justice Department. And so I gave a speech in February of 2023, really reacquainting anyone who might listen to it, including members of the bar, the antitrust bar, that highlighted how information sharing can be very pernicious. And I warned in that speech that some of our old observations about how the value of data, about the value of data being shared through intermediaries and so forth, was really turned on its head because we could not have known 50 years ago in some cases when these information sharing cases were brought that the rise of machine learning and artificial intelligence would really solve for frictions that might otherwise hamper forming and maintaining a cartel or a conspiracy. And it really challenged every conception that we had about the value of data, how easy it is to coordinate. And so obviously there was the RealPage case, which we were incredibly proud to file on behalf of the American people, and it really told a story about how rents were being artificially aligned in 43 states and with something like 1.3 million units potentially affected. And then later, when I was the acting assistant attorney general, I made the decision to amend the complaint and sue the landlords in addition to RealPage, and announce that we had flipped a cooperator that had been using some of the RealPage software. And I think that was very important to us because it informs not only the litigation strategy and the trial strategy for that case. Finally, I want to close by saying that we should be clear-eyed about the stakes. The inability of the American people to fight back against RealPage, and the fact that we were waiting on the courts and some of the cases that are proceeding to really clarify the law on this point leaves people vulnerable. The rent is still coming due, and so we don't have 5 to 10 or 15 years to wait for the law to settle. And that's why I'm so happy to know that there are representatives like the folks on this call who take their legislative responsibility seriously and are really standing up for the American people. You should also know that our inability to get a handle on algorithmic pricing is really going to be dwarfed by the King Kong of this issue, which is surveillance pricing. And again, that is the ability of certain companies to surveil your activity, your prior purchases, intimate information about you, to really target and give dynamic pricing offers to consumers that we can only imagine the ways that people can really be exploited. And so we see examples like the CEO of Delta Airlines bragging that they're going to offer, I guess, what they call individualized pricing. And I would just say that, gaps in our antitrust, privacy, and consumer protection frameworks are really going to explode this issue. And the American people need support more than ever, and now before this issue really calcifies and threatens the structural integrity of the economy. With that, I conclude. Thank you.
Thank you, Ms. Mecki. Mr. Hepner, you are recognized. Mr. Hepner?
Mr. Hepner, you're muted. You're still muted.
My apologies. Starting again. Good morning and thank you, Ranking Member Nadler, Representatives Jayapal, Johnson, and Garcia, Attorney General Platkin, and staff. Thank you so much for having me this morning. My name is Lee Hepner. I'm Senior Legal Counsel with the American Economic Liberties Project, where we have extensively investigated the proliferation of price-fixing algorithms in rental housing and adjacent markets, and more broadly across the economy. Since authoring a report on rent-fixing algorithms 2 years ago, some 18 states have introduced legislation on the topic, as have dozens of cities, in addition to the litigation that you've already heard about. Part of the reason that this hearing is so necessary is because despite the well-understood illegality of price fixing, conduct that Justice Scalia has called the supreme evil of antitrust, we've nevertheless seen these algorithms become ubiquitous. And the proliferation of rent-fixing algorithms in housing markets has, of course, attracted political attention amid a generational housing crisis. Companies like RealPage and Yardi are not shy about the function of their collusion tools. They have called their software YieldStar and Rent Maximizer. Comparable software in the hospitality industry is called Rainmaker. These names would be comical if not for their offensiveness. These products are not about enhancing market competition, but about maximizing rents, and as we've heard, restricting housing supply and occupancy in the process. Now, the core problem we've identified is that federal courts are not accounting for the ability of new technologies to further conceal illegal agreements to collude, and have meanwhile become overly concerned with the form of concerted action and not whether it deprives the marketplace of competition. As Ranking Member Nadler mentioned in his opening remarks, despite the well-understood illegality of price fixing, illegal agreements are hard to detect. And of course, this makes practical sense. No one agrees to an illegal agreement out in the open. Many speakers have talked about how smoky back rooms have given way to coded collusion that removes the need for any communication between competitors at all. But this detectability problem is really aggravated by, among other things, the Supreme Court's 2007 decision in Bell Atlantic Corp v. Twombly, which at a very basic level made the evidence of an illegal agreement more challenging to discover through litigation. That case flipped the script for plaintiffs, upending pleading standards that, as Justice Stevens wrote in his dissent in that case, were designed not to keep litigants out of court, but rather to keep them in. And I would suggest that this 2007 decision in Twombly really codified the legal landscape for the proliferation of pricing algorithms that we see today, where companies now openly advertise software that facilitates collusion. And it's why in every policy conversation, we encourage lawmakers to restore sensible pleading standards that prevailed for a century prior to Twombly. At risk of putting too fine a point on this, a credible threat of enforcement is the strongest incentive for compliance, and in its absence, lawlessness prevails. Now, the second point that I'd like to make this morning is that as courts have sought evidence of an illegal agreement to collude, they have often ignored the most important evidence, which is the invitation to collude in the first instance. The most pressing thought I'd like to impress upon this panel is the need to address that invitation to collude. And where courts are getting tripped up is in identifying the evidence of acceptance of that invitation. And what I think is a fairly myopic focus on non-public data exchanges, even where the invitation itself, again, is extraordinarily clear. I would suggest that holding out a pricing algorithm that is intentionally designed to align pricing strategies of competitors is itself a basis for illegality. Now, I don't believe that courts are there quite yet, and that, and I also believe that we're either going to need new case law or new policy to adequately confront this problem. But the fact that so many companies and tech platforms have become so comfortable, if not brazen, when advertising the collusive nature of their software is a sign of the inadequacy of existing law to confront this supreme evil of antitrust. I'm encouraged that states like Colorado and California have begun to adopt this policy approach, which is about prohibiting the distribution of pricing algorithms that really seek to align the pricing strategy itself. And I think this approach is further warranted in the context of platforms that control access to critical business resources. I think this is something that Ranking Member Nadler also addressed in his opening remarks, where platforms are controlling access to market research or advertising services, or even mere access to consumers as leverage to require adherence to a price-fixing scheme. RealPage, for instance, controls access to competitively sensitive information and allegedly conditions access to that information on adherence by landlords to a price-fixing scheme. So that leverage actually compromises the ability of landlords to deviate from the scheme. Or take the case of Amazon, cases both in California and federally, which offers a, quote, marketplace automated pricing service that increases third-party sellers' chance of becoming the featured offer by always matching the competitive price. Of course, in the same breath, Amazon offers that if a competitive price goes up, your offer price changes too. So it really calls into question whether that pricing algorithm is competitive. But the point here is that Amazon is wielding access to consumers, or at least a core advertising tool on the adoption by third-party sellers of a collusive pricing scheme. And participation in that scheme becomes less optional for third-party sellers who are independent, who are otherwise interested in independently pricing their products. Whether it's landlords or third-party sellers on Amazon or independent businesses in any industry, the imperative must be to provide these businesses with unfettered authority to set their own prices. Good policy and good law can facilitate the development of tools that achieve operational efficiencies while preserving and enhancing independent decision-making that is both good for business and good for renters and consumers more broadly. I'll conclude there, and thanks again to the committee for holding this important hearing.
Thank you. Mr. Bear, you are recognized.
Thank you, Ranking Member Nadler, and it's a privilege to be back before a number of members of the Judiciary Committee that I've had the privilege of working with over the years. I think Doha Mekki, Lee Hepner, Attorney General Platkin have set the stage very well. So I'll just offer a few brief comments and then turn it back over to you, Ranking Member Nadler, for the Q&A. So this hearing is legitimately focused initially on use of algorithmic pricing to inflate rents in the housing market. But it is sort of the canary in the coal mine, though. We have allegations that involving protein, that is beef, chicken, and pork. The same thing is going on. Hotels in medical reimbursement, where companies are coming in and offering practices, medicinal practices, physician practices, a way to align their pricing. So there is limited price competition, very much to the detriment of us as consumers. This all started in the algorithmic space about 10 or 12 years ago when I was at the Justice Department, when we uncovered two companies who were selling poster art online and decided, it was stupid for them to be competing on price. So they sat down in London and worked out a common algorithm so that anytime you searched on Amazon, the Amazon marketplace, your prices would appear the same. So consumers had to make a choice, but at a price that was algorithmically identical. We prosecuted those companies and the individuals involved criminally and secured convictions. But now what we've seen is these third-party providers coming in and saying, rental markets and elsewhere, give us your pricing data, give us your occupancy data. And by the way, we are asking your competitors for that same information. We'll run it through our algorithm and we'll give you recommended pricing and recommended units to withhold from the market. Because as the Attorney General of New Jersey said, you withhold supply, prices will go up. And that's the concern about the role these third-party providers are playing in our economy. The challenge here, though, goes beyond this. As I said, the algorithmic collusion in rental markets is the canary in the coal mine. But think about the ability of firms to write their own algorithms that say profit maximize. And the example is everybody in a particular industry writes that algorithm without any direct communication with the competitors. But the algorithm, the machine learning, will basically help a firm understand that if it cuts price to undercut a competitor, the other firm's algorithms will match that price or undercut that price. And in the long term, the math is going to work out that pricing higher is in a particular market in everybody's best interest.
Can you begin to wrap up, sir? My apologies.
I'm just about done. Thank you, Hillary. So there is that issue that I think is potentially not addressed by current antitrust law, because you don't have humans entering an agreement. You have the machines implementing the agreement. And the thing we need to do, I think, as enforcers, as legislators, is find a way to hold companies accountable for how their math is being used and it being used in a way that results in anti-competitive outcomes. Thank you.
Thank you all for your testimony. We will now turn to questions, and I will recognize Mr. Garcia for 5 minutes. I want to be respectful of everyone's time, so I'm going to ask all members to keep to 5 minutes. Mr. Garcia.
Thank you, Ranking Member Nadler. Thank you profoundly to all the witnesses for your tremendous insight on this subject. I'm going to end because I do have a terrible hard stop to get to. But let me just say again, thank you all. Mr. Hepner, sort of cutting to the chase, can you explain what would be the significance of passing my bill with Congresswoman Ballard to make this algorithmic price fixing a per se violation of the Sherman Act?
Lee, you're muted.
My apologies again. Thank you, Representative Garcia, so much, and to your colleague, Representative Ballant, for introducing legislation on this topic. Price fixing is a per se illegal violation of the antitrust laws. I think that that's part of the problem is why have these algorithms proliferated nevertheless? I think the value of the bill that you and your colleague have put forward is to address, again, a form of conduct, which is the distribution of these algorithms that are designed to align pricing strategies. And I think that you get at the problem upstream of where courts are trying to parse whether an illegal agreement exists today. So I think your legislation is profoundly moving in the right direction, and I sincerely hope your colleagues take it up and pass it.
Thank you so much. And as we know, Congress isn't exactly passing constructive legislation these days. And as we continue to support ongoing litigation and build momentum for federal legislation, what steps can states and localities take to rescind this kind of anti-competitive conduct?
I'm happy to address that question as well, Representative Garcia. 18 states have introduced legislation on this topic with a variety of different approaches. I think a multiplicity of different policy approaches is warranted here. Some of these policies are aimed at the data exchange component of it. Other policies are addressing the distribution of algorithms that align pricing strategies. But a lot of that policy making is really productive at the state level because we're having those tough conversations with stakeholders, be them landlords or platforms like Zillow, who are adjacent and involved in these marketplaces and trying to navigate the appropriate way to enhance competition and preserve the fairness of markets.
Thank you. And as I said earlier, we need a whole of government approach to address this and other kinds of anti-competitive conduct that's harming communities like the ones I represent and my colleagues represent and others in the U.S. Congress. So thank you again, and I yield back.
Thank you, Mr. Garcia. I will now recognize Mr. Johnson for 5 minutes.
Thank you, Ranking Member Nadler. For any of the witnesses, besides rental increases, how are renters being impacted by price fixing and profit-driven by these profit-driven large-scale corporate landlords? In other words, in addition to paying high rents, are there any other impacts to renters that we should be aware of?
This is Bill. Just briefly, part of the way this works is you withhold supply. And that means not only do you pay more, but you have fewer options in the Atlanta market or wherever this is going on. So it's you pay more, with less availability.
Is there any information as to what percentage of housing stock, rental housing stock, is being artificially held off of the market because of this drive up prices based on supply and demand?
The numbers I have seen suggests the RealPage algorithms often recommend withholding around 20 or 25% of the units off the market. That if everyone does it, that's the collusion part, then renters pay more and they have less from which to choose.
And can you also tell us what percentage of the owners of rental housing are using RealPage to set their rents and occupancy rates?
As I understand it, RealPage is marketing to those with multiple units because that's the way you maximize the value of the algorithm. It is less being sold to somebody who has a duplex and wants to rent the downstairs, but more to the large landowners, the real estate owners, that's the way you maximize the benefit. You get more coverage in a metro area such as Atlanta if you go to the big guys.
Yeah, what percentage nationwide of the rental units are under the control of entities that would use RealPage?
Doha, do you know that?
So the DOJ's complaint alleges that RealPage's software is currently corrupting the integrity of markets in 43 different states and in 1.3 million units. So I'm not sure the exact percentage of that, but I would say that it's not just the really large number of landlords that are using the software. There's obviously a ripple effect, right? Because if a substantial number or percentage of the landlords in a metropolitan area are using RealPage, that's going to have an impact on you, whether or not you use the RealPage software or whether you are renting from a landlord that is using RealPage or not. And so that's really why it's so pernicious. And I should note that the Justice Department's complaint, at least, alleges that RealPage's software itself is a monopoly that actually crowds out more honest forms of revenue cycle management software and other sort of products that might help landlords conduct ordinary lawful business. And so really the impacts of this are legion.
Thank you. I yield back.
Thank you. I will now recognize myself for 5 minutes. Ms. Mecki, the growth of anti-competitive behavior is not restricted to the housing market. In fact, it is said that there is a RealPage in every industry. Can you address how DOJ's litigation against RealPage may have a relevance for anti-competitive behavior in other industries as well?
Yes, thank you for the excellent question, Ranking Member Nadler. It is true that there's a RealPage in every industry. I think my colleague, Mr. Hepner, mentioned that one of the executives that developed the RealPage software actually saw what rampant information sharing in the airline industry had done for that industry. And so we see it in hotel industries. We see it in healthcare. There's actually a case pending right now against a company called Multiplan, and we know how many economic pain points we face in that industry. I should also say that these issues are so important that when I was at the Justice Department, we actually would file in the name of the United States friend of court statements of interest or amicus briefs to really make sure that courts understood the kind of collusion that was at play and the fact that it was within the reach of the antitrust laws.
And what are the real costs of failing to address algorithmic collusion?
I think that there's a really tangible economic impact, right? The prices go up. There's the fact that it creates artificial scarcity in these industries that we care about, like healthcare, like housing, like transportation. But there's a sort of qualitative problem too, which is that when people lose faith in the structural integrity of markets, it's actually a rule of law problem, right? And if they believe that corporations are somehow able to get away with things that ordinary people would not, it can erode the public's faith in democratic institutions. And that's why I think all of you deserve so much credit for trying to do something about this. There's economic liberty, and then there's sort of faith in the rule of law more broadly that's at stake.
Thank you, Mr. Hepner. Proof of agreement by competing landlords is hard to come by. Landlords aren't writing contracts with one another agreeing to collude. However, this agreement is an essential element of proving an antitrust claim. Are there methods of showing anti-competitive behavior, such as algorithmic collusion amongst landlords, that do not require explicit proof of agreement?
Thank you for the question, Representative Nadler. This is where I addressed in my comments the challenges that courts are facing when they are compelled to look at the form of an agreement over the effects of the collusive conduct. Courts will draw inferences of an illegal agreement to collude from various pieces of evidence. One of the pieces of evidence that has gotten a lot of salience in the conversation, perhaps too much, is the exchange of non-public data. Because why would a competitor share their non-public, competitively sensitive information with a competitor? It is so contrary to their economic self-interest that courts will infer that they are participating in some form of conspiracy with their competitors. There are a range of other types of evidence that courts will look to. Generally, I think that courts are applying some of these what are called plus factors a little bit inconsistently. And I think that the courts have yet to kind of arrive at a really helpful and structured way of thinking about algorithmic collusion, where the evidence of the agreement is so hard to discern, but the impacts of the conspiracies are so acutely felt by the markets. And that's where I think that courts may be taking their time, but there's also an opportunity for policymakers to step in and clarify what we mean by illegal price fixing in the context of permissive and pervasive collusion algorithms.
Thank you. Now, states and municipalities have been proactive in banning or restricting RealPage and other price-setting algorithms. For example, the San Francisco Board of Supervisors passed an ordinance banning the use of rent-setting algorithms, and other states and cities are attempting to pass similar legislation. How can such legislation at the state or local level be effective in countering concerns of algorithmic collusion and addressing the cost of living crisis overall?
Well, one immediate impact of the San Francisco ordinance, and this is one city, as my colleague Ms. Mecki stated, that is this is a problem that is impacting regional markets across the country. One city passing that ordinance caused RealPage to issue a press release that they were changing the way that their algorithm functions and the types of data that their algorithm relies upon. Now, I think that we'll learn from litigation the extent to which that is true and satisfies the concerns presented by the allegations against RealPage, but it does show the power of cities and states to actually shift the market and to provide guidance for a market where even good faith participants are seeking guidance on how to provide services to complex businesses, complex markets. So I do think that states and cities have a critical role to play in evolving the law, evolving the policy, and providing clarity to markets where it frankly is not existing otherwise.
To show a violation of Section 1 of the Sherman Act, courts require evidence of some sort of meeting of the minds. Could you speak to how legislation or antitrust jurisprudence should adapt in response to the proliferation of AI and algorithms more generally?
and I'll defer to my colleagues here as well. But again, my preference would be that the law evolves to really focus on the distribution of algorithms that align pricing strategies. I think that if companies are holding out a collusion tool, if they are advertising, as we have seen it many times, that this tool can be used to hike prices and to align pricing strategies, if they are using that tool to deter competitors from setting their own prices on their own independent discretion and decision-making authority, that itself should be prohibited. We should not be seeing the advertisement of these tools and the proliferation of these tools upstream of their use.
If I might add in, I think this is an important point, and one place where Congress might be interested in taking action is sort of recognizing that a lot of this coordinated conduct really falls on the collapse of many different kinds of coordinated conduct, cartelization that the 1890 Sherman Act attempted to or intended to cover, collapsing into the law of conspiracy. And so figuring out ways to bring in more inferences of coordination agreements within the meaning of Section 1, I think is really important. And at the risk of embarrassing my first boss, Bill Baer, Bill really was on the front lines of creating some of the most important precedents that we have in the courts of appeals on coordinated conduct. So, Bill, I'm not sure if you have more to add here, but personally, I'd love to hear from you.
Look, briefly, Toys R Us was a case where a dominant retailer went to the toy manufacturers and said, we're getting eaten alive by Costco and other big box stores. And you got to stop selling hot toys to our low-cost competitors. And the competitors said, well, we're not going to do that unilaterally if you can give us assurances that the other toy manufacturers will stop selling to Costco and the like. Fine. So Toys R Us went around and did that. We found out about it. We sued. Seventh Circuit affirmed this as a hub and spoke conspiracy. More recently, it turned out that book publishers were very upset with Amazon for selling books at low prices. And the book publishers and Apple, who wanted to enter the market and challenge Amazon, agreed that they would support Apple's entry into the market as long as Apple had high prices. And the publishers said, if we can work this out, then we'll just stop selling through Amazon. So there is precedent there for taking this on. It is a little more complicated when the algorithms figure into it, but there's no reason why existing law can't deal with this meeting in the minds issue.
Well, I want to thank all of our witnesses and members for an excellent discussion this morning. Today's briefing will inform our work as we continue to tackle this important issue and work to lower costs for renters across the country. Thank you again, and we are now adjourned.